I'm Attorney Zach Townsend, here today to discuss with you the prove-up hearing. A prove-up hearing is how lawyers refer to the finalization date of the divorce, because that's the date that the judge gavels down the divorce decree and dissolves the marriage, and the bonds of matrimony are severed. A prove-up hearing is for uncontested cases. If your divorce case is contested, then it will not be proceeding to prove-up. Instead, it would likely proceed to trial. At the prove-up, the court finds that there are grounds for the dissolution, that both parties are entitled to a dissolution of marriage, and that the agreements that both parties signed can be incorporated into the divorce decree. The divorce decree, which is entered at the prove-up, is also known as the judgment for dissolution of marriage. The judgment for dissolution of marriage incorporates important documents into the judgment itself. Those documents are the marital settlement agreement, and if there are children, the parenting plan of the parties. At the prove-up hearing, the court not only finds grounds for dissolution, meaning that the marriage is irretrievable and broken, and irreconcilable differences led to the irretrievable breakdown of the marriage, and attempts at reconciliation failed, and future attempts would be fruitless. That's grounds. So the court makes that finding. But perhaps more important is that the court approves and adopts the marital settlement agreement of the parties, and approves and incorporates the parenting plan of the parties. The court will determine whether the parenting plan is consistent with the best interest of the minor children, and if it is, it'll be ordered. The court will also verify that, yes, this is your signature on the parenting plan, and yes, you agree to this voluntarily, and you were not coerced into signing. Similarly, the court will review the marital settlement agreement and make a determination that the marital settlement agreement is fair and equitable and not unconscionable. If that's true, and the court verifies that this was a voluntary agreement, entered into by both parties knowingly and intelligently, then the court will adopt and ratify the marital settlement agreement. The marital settlement agreement and the parenting plan are contracts because they're signed by the petitioner and the respondent, and they're bound to those agreements. However, at the prove-up, these documents are incorporated into the judgment for dissolution of marriage. That means that it's no longer just a contract, but it's like a contract on steroids, because these are now the judge's words. If the marital settlement agreement is not complied with, that can be contempt of court. If the parenting plan is violated, that can also be contempt of court, because now this is not just the terms of the parties, this is the terms of the court. And that's why the two documents, one if you have no children, are incorporated into the judgment for dissolution of marriage. There will be basic questions that are asked of both parties. It's not a high-stress, high-pressure hearing the way it would be if the parties had to go to trial, but it nonetheless requires both parties to be sworn under oath and to testify that what they are telling the court is true and accurate and correct to the best of their knowledge, and to provide the facts and the basis for the divorce to be granted. Typically, at least one party is required to appear at the prove-up. We advise that both parties attend, because if you're not present, you can't speak up for yourself. That's a little bit about the prove-up hearing. Thanks.